The Leader of the Opposition.
Thank you. We already...
It's not that late, Mr Deputy President.
No, but I'm having a shocker.
Mr Deputy President, I lead for the Opposition on the Crimes, Domestic and Personal Violence Amendment National Domestic Violence Orders Recognition Bill 2016. The Opposition does not oppose the bill. The object of the bill is to give effect to the New South Wales component of a national recognition scheme for domestic violence orders. The agreement as to a national recognition scheme was announced, or perhaps more accurately re-announced, at the Council of Australian Governments in December of last year. In December 2015, every state and territory agreed to introduce laws relating to a national domestic violence order scheme to hold domestic violence perpetrators accountable throughout the Commonwealth of Australia. Under the scheme, domestic violence orders will be automatically recognised and enforceable in any state or territory. Domestic violence orders from New Zealand will also be able to be registered as part of the scheme. New South Wales, as is so often the way, is the first to introduce model laws through this bill. The model provisions were considered by the Advisory Panel on Reducing Violence Against Women and their Children. A number of relevant stakeholders, including Legal Aid New South Wales and the Chief Magistrate of the state, were also consulted during the drafting of the bill. And the bill will allow an individual to apply to the Registrar of a Court for a declaration that their existing domestic violence order is a recognised domestic violence order in New South Wales and therefore part of the national recognition scheme. This will give some scope for domestic violence orders made before the commencement of the scheme to be recognised across the Commonwealth. However, an order that has been declared to be subject to the national scheme will only be enforceable against a defendant in New South Wales on the date the declaration is made. I note the informed, constructive and passionate contributions to this debate in the other place by my Labor colleagues, the members for Maitland, Blue Mountains and Wollongong, and that of John Robertson, MP for Blacktown. Like him and others in this Parliament, I'm a White Ribbon ambassador and we take this issue very seriously, as I'm sure all members do. As my local MP, Searle, member for Blue Mountains, noted in her contribution, domestic violence is a major betrayal of trust that has long-term psychological and physical impacts, as well as intergenerational effects. And I think it's easy to lose sight of that intergenerational dimension. It's not just something, however regrettable, that occurs between two people. The impact is much more widespread. What happens to a woman and her children is self and beyond their control. However, they can survive domestic and family violence and move on with their lives. Like the member for Blue Mountains, I pay my respect to the victims and survivors, to all of those who assist them, the refuge workers, the domestic violence counsellors, the women health centres who do a sterling service, the police and ambulance services and others. Like many people in this place, I believe more work is needed in this state to effect change across a number of our systems that are critical to the protections offered by our system of domestic violence orders in this state. The primary aim of the scheme is for existing domestic violence orders known as DVOs issued in one jurisdiction to be automatically applicable in another jurisdiction. This can happen at the moment, but it requires the protected person to make application, which can be problematic. The person protected may not know they have to go through that process. They may be apprehensive to take such action because it may alert the offender to their presence in that jurisdiction, or they may simply not want to undergo the traumatisation of further involvement with the justice system. Turning to the bill, new Part 13, capital B, will be inserted into the Crimes, Domestic and Personal Violence Act, entitled National Recognition of Domestic Violence Orders. Proposed Section 98 capital Y establishes as recognised DVOs in New South Wales an interstate DVO made in a participating jurisdiction or a registered foreign order. The only foreign jurisdiction involved to date is New Zealand. Because of the way intervention orders in South Australia and violence restraining orders in Western Australia are structured, they may include matters unrelated to domestic violence. Only orders addressing a domestic violence concern are included in this scheme, in the bill. Proposed Section 98 capital Z provides for the variation in New South Wales of DVOs from other states, and proposed Section 98 capital Z capital A provides for their revocation. Proposed Section 98 capital Z capital B provides for a recognised DVO to prevail over earlier comparable DVOs. Proposed Section 98 capital Z, capital D, provides for recognised DVOs and recognised variations to be enforceable in New South Wales against the defendant. They are to be enforced as if it was a local DVO. This also extends to its impacts on licences, permits and other authorisations. Proposed section 98ZI specifically relates this to a firearms licence, and proposed section 98ZJ extends it to a weapons permit. Division 3 deals with variation and revocation of recognised non-local DVOs. Division 4 deals with exchanges of information. The provisions are not limited by the information protection principles of the Privacy and Personal Information Protection Act. Madam Deputy President, I refer now to correspondence received today from the Women's Legal Service New South Wales Specialist Community Legal Centre. The Centre is supportive of the legislation, and they recognise progress on the automatic recognition of a domestic violence order in any jurisdiction within Australia. However, they do have some concerns. They note that over the past few years they have seen a significant increase in technology-facilitated stalking and abuse. That is the use of technology such as the internet, social media, mobile phones, computers and surveillance devices to stalk and perpetuate abuse on a person. In particular, the Centre has been seeing a concerning trend of technology being regularly used against women by perpetrators as a tactic within a wider context of domestic violence, including the non-consensual sharing of intimate images. Now, I pause at this moment to note that the Standing Committee on Law and Justice of this Parliament has recently delivered a report on the so-called revenge porn, where they deal with the issues arising in the privacy context and recommend a statutory tort or cause of action in relation to privacy based on the Australian Law Reform Commission model. And they have done a very detailed and thorough piece of work which touches on this very issue raised by Women's Legal Services New South Wales. In particular, the Centre is concerned about one aspect of the bill which I'll just briefly touch on, that is proposed section 98 capital Z capital F 4, which I will find, which reads, and I quote, "This section, which is about a contravention of an enforceable recognised DVO, does not affect any law of New South Wales that requires a geographical nexus to exist between New South Wales and an offence for a person to be guilty of an offence under the law of New South Wales." What the Centre is concerned about in relation to this provision is that they're concerned that it may seek to exclude technology facilitating stalking and abuse where it takes place across different jurisdictions. And they seek assurance that abuse which does take place across state and territory borders will in fact be covered by the bill. Madam Deputy President, I think that concern can be allayed, but I ask the Honourable Parliamentary Secretary to get some advice on this.
Yeah, me too.
Section 10 capital C subsection 2 of the Crimes Act, which because of section 10 capital A extends to all criminal offences, states that a geographical nexus exists between the state of New South Wales and an offence if the offence is committed wholly outside the state, but the offence has an effect in the state. Now, on the facts given in the attached letter from the Women's Legal Centre, Women's Legal Services New South Wales, this would seem to be satisfied despite the outcome in the particular case they refer to. Because cyber stalking of persons in New South Wales has an effect in New South Wales, there would appear to be no need to make any change in the bill before the House. As we understand it, the bill merely maintains the status quo in the case of prosecuting persons for contravening a prohibition or restriction in a DVO that is recognised in this state. It should be noticed that section 10 capital A subsection 3 of the Crimes Act states that if a law that creates an offence makes provision with respect to any geographical consideration concerning the offence, that provision prevails over any inconsistent provision of Part 1 of the Crimes Act. Proposed section 98ZF6 makes clear that there's no intention to override that part. Now, Madam Deputy President, I may be wrong about this analysis, and I do ask the Honourable Parliamentary Secretary in his reply to give the House and Women's Legal Services New South Wales an assurance that abuse which takes place across state and territory borders will be covered by the bill, and if for some reason it does not, to undertake to come back to the Parliament to correct the legislation. Madam Deputy President, when introducing the bill, the Attorney went to some trouble to claim that New South Wales was leading the nation in addressing domestic violence. At the end of her second reading speech, the Attorney suggested a significant delay in proclamation to allow for interim information sharing capabilities to be put in place, but she gave no hint as to how long that would be. I asked the Honourable Parliamentary Secretary in his reply to indicate how long that will be. The Attorney appeared to concede it would take several years to fully implement a comprehensive national DVO information sharing system, which does seem to put a dampener on the government rhetoric surrounding this legislation. If the government cannot tell us when it's going to be properly implemented. So there's no time frame for full implementation, and there's a lot of issues to do with information sharing that would have an impact on that. As was noted in her contribution in the debate in the other place, the member for Maitland indicated that there was a substantial body of evidence regarding the difficulty that women in our community have in accessing apprehended domestic violence orders, enforcing them and getting appropriate services due to the shortage of spaces in refuges and a lack of response services from refuges because of funding cuts. And of course that is certainly the case. It's not enough to increase the portability of domestic violence orders if recommendations to approve their operation or the services that are needed to support their operation are simply not properly in place. The Honourable Member did discuss the domestic violence death review team established by the former Labor government in 2010 and noted that there hasn't been a lot of action from it. There were 8 recommendations from reports over the years from 2011-12 to 2013-15 that go to the heart of the operation of apprehended domestic violence orders and would be integral to improving outcomes for women who seek to escape domestic violence. An annual report being released every couple of years is not adequate. The Women's Domestic Violence Court Advocacy Services, there are 28 services servicing 114 local courts in this state, but of course women often have to travel extensive distances to access those services, or the advocacy service themselves have to engage in extensive travel, often causing difficulties in providing proper levels of service and support. And although there has been some increase in the funding of these services, there's also been a massive increase in the number of clients as a result of government changes requiring every domestic violence report from the police to be followed up by the NGO with no additional funding. In a single 3-month period in 14-15, there was a 75% increase in usage, outstripping any increased funding provided by the government, which is a significant problem. One of the proposals that the Labor opposition has advocated for has been a specialist domestic violence court, something which we took to the election in 2015, and we feel that the proper implementation of Labor's positive plan in this area would go a long way to achieving more justice for victims of domestic violence in New South Wales, ensuring, of course, that it's not just about having a specialist court with trained judges and officers, but to make sure that there is connected to it the proper wraparound services that are needed to support women seeking to flee domestic violence, not merely the machinery which churns out the orders. The interim system that the Attorney will implement as a result of this legislation passing will not be as effective as the permanent system. The COAG communique from December 2015 stated that they had agreed to, and I quote, "in the short term establishing an interim information sharing system that will provide police and courts with information on all DVOs that have been issued but will not have the same evidentiary or enforcement capacity as the permanent system," quote unquote. As the Shadow Attorney did in the other place, I asked the Parliamentary Secretary to specify exactly what the inadequacies in the interim arrangements are, as referred to in the COAG communique. What is it in that interim system? What is it that the interim system will not be able to do that the permanent system will be able to? As I indicated, these questions were posed by the shadow attorney of the attorney in the other place, but the attorney in her reply did not address those matters. As long as goes January 2015, the then Prime Minister said domestic violence would be on the COAG agenda and he would ask for urgent action. In April last year, COAG also agreed to urgent collective action, and a year later the first legislation was presented to a Parliament. The national scheme is a useful reduction in red tape regarding domestic violence orders, and it will help victims who move interstate or who live near borders or perhaps work in one state and live in another. However, some of the language of the government has been too self-serving or self-congratulatory. As Jan Wangman of the University of Technology Sydney states, and I quote, "COAG's proposal for automatic recognition would cut the red tape of having to register a DVO in a new state, but is it a new idea or a sign of progress? Hardly. The need for automatic recognition was recognised by the National Council to Reduce Violence Against Women and Their Children in 2009 and was subsequently included as part of the National Plan to Reduce Violence Against Women and Their Children 2010-2022 as a key action for Australian governments in 2010-2013. Bracket C strategy 5.3 end brackets. In other words, Australia is already running years behind in this area. What is currently being proposed also fails to grapple with the critical problem of enforcing those DVOs, regardless of where you live in Australia. More work needs to be undertaken in this area to assist women in reporting breaches, ensuring police act on such reports, and that any breaches found by a court are treated seriously." Unquote. Ms Wangman also points out that information sharing, while essential to enforce orders, is hardly new, and this is hardly advancing at a rapid rate. In 2014, the Commonwealth Government provided Crimtrack with $3.3 million to work on this issue, and I understand it's still a long way from completion. I note a Legislative Council Committee report of the previous Parliament recommended on the need for better data capture some time ago, which has still not been done. COAG is playing a slow game of catch-up, and none of this means very much if services are not being properly funded or delivered on the ground. With these cautionary words, the opposition does not oppose the bill.